May please your lords. My lord, the petitioner in this petition, my lord, he is presently working as a superintendent of police in Hailakandi district, my lord.
When the money decree was passed?
Yes. Yes.
When it was passed?
My lord, at page number 33 on 20 November 2024. 20th November 2024.
Page number 30?
33, my lord, is a relevant portion, my lord. 33. It is decreed that all the defendants are jointly and liable to pay an amount of rupees 5,36,045 with interest at 6% per annum. Now, my lord, we are not disputing this thing, my lord. We have not even preferred any appeal. My lord, the only thing is that, my lord, we are in constant touch with the higher authority, my lord, and we have taken necessary steps, my lord. Once the financial, my lord, sanction is received, the money will be released, my lord. That we have brought to the notice of the court on several instances, my lord. Lordship will kindly see it.
And when the execution case was instituted?
Execution case, my lord, will kindly see at page number 42.
42.
42. This is the execution petition, my lord. It was filed on 29/4/2025. And page number 44 is the first order. The execution case was registered and the decree holder was directed to submit a list of articles for attachment. Immediately thereafter, my lord, on coming to know about that, my lord, we instructed the government leader that lordship will find at page number 51 to apprise the honorable court below, my lord, that what steps we have taken, that and the matter has already been taken up with the Assam Police Headquarters for obtaining financial sanction and allotment of fund thereof. So thereafter, my lord, the government leader, my lord, informed the learned court below at page number 52. Next page, my lord. Thereafter, my lord, some time was given. After that, lordship will kindly see page number 56 on 15/12/2025. This order was passed, my lord. Last paragraph. In view of the foregoing and in order to ensure compliance with the directions of this court, I am of the considered opinion to issue summon of appearance upon the JD. And 9/1 was fixed for appearance. After coming to know about that, my lord, will kindly see page number 57. We wrote a letter to the government leader at page number 58, my lord, mentioning all the correspondence which we have taken on various occasions, my lord. 26/3, 12/6, 5/7, 23/9, 2011, my lord. And to apprise the honorable learned court below, my lord, regarding this, my lord. But what happened, my lord, on that particular date, lordship will kindly see page number 62. The government leader, without, my lord, placing that, my lord, just filed a mechanical petition that because of business, my lord, the JD could not take necessary steps. At page number 62, second paragraph, that the superintendent of police, being business with other official works, could not collect the details of action taken. Thereafter, my lord, the learned court below, my lord, at page number 63, directed, my lord, the personal appearance of the SP on 22 January, my lord. On this particular day, my lord, on 22 January, my lord, I filed this present petition, my lord, at page number 74. Informing the learned court below all the, my lord, correspondence which we have taken, and also, my lord, praying for exemption for personal appearance, citing the judgment passed by the Honorable Supreme Court, my lord. But the learned court below not only rejected our, my lord, petition, but also, my lord.
No, there is another judgment of the Supreme Court in Periamal, in the case of Periamal.
Yes, I agree, my lord.
That has to be executed
Yes,
within
that
a
has to be
period of
executed.
6 months.
Yes, but the thing is that, my lord, here the case is that, my lord, the judgment debtor, my lord, is not personally liable, my lord. My lord, he is
No,
not.
maybe.
Yes.
Decree was passed against him.
Decree is passed against the office of the superintendent of police, my lord.
Let him deposit the amount.
Yes, my lord. That is why, my lord. My lord will kindly see. The latest correspondence, my lord, which we are, my lord.
No, we are not concerned with this correspondence. You are bound to pay the amount.
We
you
are bound to
deposit
pay
the
that.
amount.
That is why, my lord, we have not preferred any appeal, my lord. This is totally not disputed, my lord. And regarding, my lord, personal appearance, my lord, that can be, my lord, kept in abeyance, my lord. till my lord this money is released, my lord.
No,
Because
no,
still,
let him appear and file an application before the court.
my lord will kindly see, my lord, the
No, no.
lordship will kindly see the, my lord, order passed by the learned court below, my lord will kindly see. At page number, my lord, 82. 82. Second paragraph, my lord. What was, my lord, what was the, my lord, finding of the apex court, my lord, and what was the finding arrived by the learned court below, my lord? Lordship will kindly see. Now, if we see the materials available in record, we will find that non-cooperation of senior superintendent of police, my lord. There is absolutely, my lord, no question of non-cooperation, my lord. The Honorable Supreme Court in the judgment, I have placed the judgment, my lord. Lordship will kindly see the judgment. At para number, my lord, 43.
No, no, that case and the present case would be different, distinguishable.
No, my lord, the thing is that the source of power.
Here you are the decree, you are the judgment debtor.
Yes, my lord, the source of power which the learned
So
court below is.
ratio laid down in other case will not be
But even, my lord,
applicable in
that
your case.
also, my lord, pertains to personal appearance, my lord, of public officers, my lord. Lordship will kindly see the source of power relied on by the learned court below is Order 21, Rule 41. And that, my lord, is only upon the application made by the decree holder. There is, in this matter, my lord, there is no application made by the decree holder, my lord, for examination of the judgment debtor, my lord. Without any application, my lord, there is no question of exercising the power under Order 21, Rule 41. And if your lordship will see section 81 also, my lord, in case of suits against public officer or against state, my lord, there is not a specific provision is there, my lord.
Maybe.
But before that, my lordship will kindly see the judgment. In, my lord, 2024 3 SCC page number 1, my lord, which was also relied before the lower court below, my lord. Kindly see para number 44.
No, I have already told you that ratio laid down in that case would not help you because you are decree holder, no, judgment debtor here.
Yes, that is why, my lord, we are also not disputing that amount, my lord, that, my lord, the burden cast upon us for payment. We are not disputing that. The only thing is that, well, we are helpless regarding that, my lord. If the JD
No,
was,
that helplessness
was personally
that has
liable,
to
my
be
but-
has to be taken
yes,
care of.
once the, my lord, higher authority, my lord, sanctions the budget, my lord, we are ready to release the amount. In fact, my lord, in other money suits also, my lord, as soon as, my lord, the financial sanction was received, we release the amount, my lord. Here, my lord, as soon as it,
Police department or standing counsel, police department or Borman is ready, ready to Borman, Miss Borman, Bormati Borman. So he will call the government advocate.
my lord,
We'll take up the matter after some time.
my lord. Highly obliged.
Also, kindly pass over the for timing, Lord. My senior is in other court.
Okay.
Two and three আছে বলিস
2 IMN. Item the 2 IMN. Item 2.
Yes. Who is yes, yes, Mr. Counsel.
Yes, my lord.
You are appearing
For
for
the appellant.
Yes.
Sorry,
Sorry.
Hmm?
Yes, let's
my lord. He is in wrong motion.
yes.
My lord, the in this appeal, my lord, four substantial questions are made, my lord. So we have challenged the judgment passed by the appellate tribunal
for violating the section 45, man. Page number 6.
So the question was whether the learned single member can
Pass the judgment.
pass the judgment.
Yes, my lord. That is in terms of the 45. The 45 mandate is, my lord, the appellate tribunal has to be constituted with 3 members. One is chairman, another is judicial member, another is technical member. That is, my lord, mandatory provision. It is not directory. Can the section 45 may be, my lord, read, my lord. 45. I mean, be read, my lord. The appellate tribunal shall consist of a chairperson and not less than 2 whole-time members, of which one shall be a judicial member and other shall be a technical or administrative member, to be appointed by the appropriate government. This is the, my lord, dictum of the law. Here, my lord, the judgment, it was passed by a single person, single member of the tribunal, my lord. That is, we have approached before this court for challenging the judgment, for setting aside the judgment. In terms of section 45, my lord, the judgment is per se illegal, my lord. This is the moot question of the, my lord, the issue.
Okay. And you have referred these decisions?
No, my lord, in this land there is no decisions, my lord. There are 2 decisions have been referred by my learned friend in this case, my lord.
Okay.
That is not applicable to this question. My lord, this is RERA tribunal authority, my lord. This is RERA authority, my lord. Not appellate tribunal, my lord. Authority is something different and tribunal is something different. But constitutional,
And this decision relates to
the RERA authority, my lord.
authority.
Authority. The authority passed by judgment and that was challenged before the tribunal under section 45, my lord.
Okay.
In this judgment, which referred by my learned friend, is not relates with the appellate tribunal, my lord. This is a basic crucial, my lord. And we have searched, there is no, my lord, reported judgment has been find out, my lord. In the judgment of the Punjab and Haryana High Court, my lord, he says something is different, my lord. Here, my lord, in the earlier occasion, there is a question was raised by the other side, my lord. This is very important. Where the section 45 of the RERA Act is a mandatory provisions, and in section 55 of the Act, my lord, page 44. That is the crux, my lord. Section 55.
Yes.
45 is, my lord, there are mandatory provisions, is there 3 members are required to pass a judgment in the appellate tribunal. It is, my lord, admitted fact and it is correct, my lord. The judgment was passed by a single bench of tribunal, my lord. So it is invalid according to me, my lord. My lord, now the section 55. Whether this section 55 of this Act inherited this judgment passed under section 45, my lord. That is the crux of the case, my lord. If, my lord, 45 is, my lord, read whether the mandate of section 55 can override the section 45 or not, my lord. That is the crux of the case, my lord. (45)(c) says, my lord, any irregularity of the procedure of the appellate tribunal not affecting the merit of the case My lord, if it is so, my lord, then why 45 is there, my lord? So we cannot go to section 55, isolating the section 45 of the Act, my lord. It is the mandatory provisions, it is requirement, my lord. It is administrative capacity, my lord. Kindly see the vacancies, etc., not invalidated proceedings of appellate tribunal. My lord, this is my lord, in case of the administrative capacity, my lord. If the 45 is not there, my lord, there should be an order from the government. The appellate, single member of the appellate can be act singly. That is not here, my lord. That is my humble submission. The judgment which was passed, it is per se illegal in terms of the section 45 of the Act, my lord.
Okay. Yes, madam, what is your contention?
Your Lordship. Lordship have already gone through the section 45,
Mm,
this 52 and 55.
mm.
Now the 45 speaks about the composition of the member. That is one judicial member and another one is a technical member and administrative member. So this is very crucial point here we have to see. Reason being, the other member is a technical member and an administrative member. Our order has been passed by a judicial member being a chairperson. He has also the delegation of power. He is having the administrative capacity also. He is dealing with the matter. That apart, since this is the composition keeping in mind, legislator has kept in mind this 45. That is why sometimes exigencies appear. There may be certain vacancies. That is why this 52 and 55 is incorporated here. Legislature was not unmindful of giving this 42 and 55. Now, 55. They are mindfully and for the interest of the justice, these two sections has been incorporated because sometimes it may happen there is a vacancy of technical member or an administrative member. In some of the tribunal lordship, there is a judicial member and technical member. In some of the tribunal, it is known as an administrative member. So when the order is passed.
No,
by-
no. Is it provided in the act that if an order or judgment is passed by the judicial member,
Yes.
whether whether it will be valid?
Yes, it is valid. I have the judgment, your lordship, to that
Yes.
effect. And from
So it
we rarely has been distinguished with regard to the capacity of the technical or administrative member and judicial member and chairperson.
no. Is it provided in the act itself
Yes, it
or
is
in the rule?
provided in the act and supported by the Supreme Court also by distinguishing and
In which section of the act it is provided?
in the act it is not distinguished. Since this issue has been raised before to the Supreme Court,
Mm,
then it has been distinguished.
okay.
And it is here only in the before the Haryana real estate. Has been distinguished though the petitioner has raised this point in this issue. I am coming to the lordship, in the page number 2.
No. This is the decision of the appellate tribunal.
No, it has referred the new take also. New take is in page number 3 also. Page number 3. New take, judgment in Janta Land and Promoter Private Limited, Union of India versus Surat, was examined by the Supreme Court in tennis new take case Supreme. As regard the jurisdictional issue, it was held that members of the authority can decide the matter sitting singly. The beneficial interpretation of section 55 supported by doctrine of necessity needs to be invoked. Thereafter, I am coming to the, this is whole thing. This was also referred to the regulations 29/2024 which rates and.
No, madam, you submit the decision of this MS Newtech Promoters and Developers Private Limited
The decision
and furnish a copy to him also.
and paragraph number 7, last paragraph. Thank you. Be there with me for a few minutes.
Mm,
Paragraph number 7. Further, it has been noticed that the impugned order has been passed by the administrative officer. There is nothing on record to show that the administrative officer has been vested with the power to pass the order of the nature impugned in the instant case. It is thus speculative how quasi-judicial power were exercised by the said officer judicial and quasi-judicial power cannot be delegated to other officer as that would be VCL judicial.
No, that is not the case here.
Now I'm coming to this act, Real Estate Regulation and Development Act 2021, where in chapter 20, it has been clearly given, Your Lordship. Assam Real Estate Appellate Tribunal Regulation 2021.
It is settled.
Chapter 20.
So,
Assam Real Estate Appellate Tribunal Regulation 2021.
no, this is of 2017.
I have 21.
Okay. Which provision you are relying upon?
26.
Yes.
26 of Assam Real Estate Appellate Tribunal Regulations 2021. Nothing in this regulation shall be deemed to limit or otherwise affect the inherent power of the tribunal to make such order as may be necessary for meeting or securing the ends of justice or to prevent the abuse of process of the tribunal. So, doubly it is protected by these regulations, Your Lordship. 55 is there, 52 is there. It is protected, keeping in mind 45. Keeping in mind the composition, subsequently these conditions are given. 52 and 55. And thereafter this is protected. Otherwise, still the tribunals are going on. Then in that event, all the case will become invalid, vitiated. And whether the legislator are shutting their eyes without knowing this, looking to this fact, these exigencies will come to meet the necessity and to meet the ends of justice. These 52 and 55 is given. That apart, now the 26 has also been given.
Yes, Mr. Das,
Is also there.
have you gone through that?
Yes, my lord. This is, my lord, the section 25 is the, my lord, general powers to amend the recticity, my lord. My lord,
Till that, Your Lordship, nobody is appointed. And it is in the knowledge of the government. It is also in the knowledge of the government that all the matters are going on. Why only in isolated matter we have the victim? None of the members.
No,
have
this is a appointment order.
Yes, Your Lordship. Thereafter, no administrative member, no technical member is appointed. Till date. And it is in the knowledge of the government.
No, maybe.
Regulation is also there.
Maybe.
2021. And that is.
But
why this-
whether section 45 provides for?
But 45, looking to 45, 52 and 55 has been made. That in the event of vacancy, 45 is made, this is the general thing. However, specifically, in the event of vacancy. So 45 has to be made with 52 and 55. There is no need of giving 52 and 55. What is the use? How the legislator will give these two sections unnecessary section if its application is not. 45 always read with 52 and 55. Your Honor.
Okay, you read the section 52 then?
52.
Yes.
If for reason other than temporary absence, any vacancy occurring in the office of the chairperson or a member of the appellate tribunal, the appropriate government shall appoint another person in accordance with the provision of this act to fill up the vacancy. And the proceeding may be continued before the appellate tribunal from the stage at which the vacancy is filled. Means the proceeding, whatever has been taken, thereafter, when new member will come, then it will start from there, not from the beginning. Just to save that. Here, from my little knowledge, I understood this. From the date of appointment, the stage will not go back. It will proceed prospectively, not retrospectively. That is from my subject to correction, your lordship. This is my little knowledge what I could able to understand. And thereafter, 55 says vacancies etc. not to invalidate proceeding of the appellate tribunal. Here it might be saying even if any single bench has proceeded with the case, in the event of vacancies, that is not going to invalidate in both the cases, whether it is their existing one or which has already passed the order. In 55, no act or proceeding of the appellate tribunal shall be invalidated merely
Okay.
by reason of any vacancy in or any defect in the constitution of the appellate tribunal or any defect in the appointment of persons acting as a member. It has doubly protected. Even for the defect, it has been incorporated in 55. Defect in the appointment of person acting as a member of the appellate tribunal or any irregularity in the procedure of the appellate tribunal not affecting the merit of the case. So here threefold protection is given.
Hmm.
In 55.
Okay, okay, we will see and pass the order. Item number 3 is also
Yeah,
the
same,
same
my lord.
matter?
I related just a citation of the Supreme Court of India.
Just a minute, I think. Would like to brought your lordship, your attention, lordship. This notification incorporated 41, 45, and 46. So keeping in mind this 45, this has been notified.
Hmm.
So legislator, they have some knowledge. And in 55, threefold protection has been given.
Hmm.
Vacancy, irregularity, even defect.
Hmm.
Threefold protection. And thereafter this notification is there, section has been informed.
No, that is only by appointment letter, that is.
Keep in mind that there is a vacancy.
Hmm.
Keep in mind that there is a vacancy.
That notification would not help you, would not advance your argument.
I have subject to correction, lordship.
Yes.
Well, my little submission of Supreme Court in a case
Hmm.
is 1996 my lord, held. It is well settled that every provisions of the Act needs to be construed harmoniously with a view to promote the object and spirit of the Act.
Hmm.
But while doing so, no violence should be done to the plain language used in the section. It is the principle that needs to be applicable while constituting the provisions of the Act. This is my humble submission before lordship is the Act. What he says that must as per the Act of the section.
Hmm.
Rules has to be followed. Act has to be followed.
Submitted to the court.
Yes, my lord.
That point of time, your lordship, this tribunal system was not existed.
Maybe,
That is
but
Harmoniously, that is why this has been harmoniously done,
Hmm.
52 and 55.
okay.
Because nobody is going to prejudice by that. And
Hmm.
this point has never raised before the appellate.
No, no.
First time here it is.
If my lord, section 55 is applicable to the section 45, there should be the legislator should my lord, added a proviso that due to lack of this quorum, these provisions to be applicable. That is not done by the legislator, my lord.
Hmm.
So it is a separate and it is administrative capacity. They cannot, my lord,
Hmm.
wait it together, my lord.
Okay.
Your lordship, which is the general practice,
Hmm.
they will have to deposit some percentage of the amount, neither it has been deposited in the appellate tribunal, nor it has been deposited.
No, we have not admitted the appeal till now. Next item.
Obligement.
Orders. I remember why.
May I please have can I take them for the?
Yes.
May it please your lordship. Lordship, I preferred a revision application under section 115 against order dated 13/12/2023, madam. But while preferring the application, there has been a delay of 208 days, my lord.
Mr. Bora, you have filed objection here.
Yes, I have filed. There is no question with them. Last year in the month of January itself, right? Yeah, applications yes got dismissed for non-compliance of the provision under Order 22 Rule 14.
Mm.
And that order is put under Senate. Here the question is about my objection. There are three petitions. Only the petitioner number one, he approached the
No,
legal service.
Mr. Bora, we are not on the merit of the petition now. We are only on the point of condonation of delay.
Yes.
Do you have any objection in
Yes,
condoning
that's
the
why I
delay?
filed my application number.
Okay. What is your state?
My son is that, my lord, in the entire application,
Mm.
what is the starting point of limitation? That is not stated. And another aspect is that there are three petitions.
Mm.
Only the petitioner number one approached the district legal service. And what the petitioner number two and three, they are doing throughout this period from 3/1/2024 to the month of July, that is nowhere explained by them.
Mm.
So they have not approached the district legal service authority there
Mm.
after dismissal of the execution case.
Mm.
Only the one he approached. As per their own version within the.
No, that's all right. One can also approach.
Yes, but what about two and three? Now, when they have not approached.
No, they
and
may not,
nothing-
they may not be interested in pursuing the
Why they have
petition.
done, my lord, now they are joining
Oh,
these two and three. They are also before your lordship.
today.
Yes. So the three petitioners who are the plaintiffs in the suit, they are the petitioners. So two and three, they have done nothing. If they have done nothing, then how can they join the petitioner number one?
Yes, Bora?
My lord, it is admitted that only the petitioner number one had approached the
Legal
legal
Service
service
Authority.
authority. My lord, the delay part, which has been explained herein, my lord, is regarding the fact that the file was handed over to another legal aid counsel, and that legal aid counsel returned the brief to the authorities, and then I was engaged, my lord. So before that, although the respondent, the petitioner number one has approached, and if he has material objection regarding petitioner number two and three, they may be struck off because I'll be taking the benefit of Order 41 Rule 4, my lord. Only one can also come, my lord. Since appeal provision is not there and it's a revision, so Order 41 Rule 4 will apply, my lord. Only one of the appellants may also come challenging the decree or on behalf of the others. That part may be considered, my lord. And regarding the delay part, my lord, that has been explained. My lord, the file was handed over to me on 16/7/2024, my lord. And thereafter, the condonation petition as well as the CRP, the revision petition was filed in the month of 22/10/2024. After going through the records and all, the papers were not complete. As such, I had to call the petitioner number one from Nagaon. And he supplied with the requisite materials, and then only I could draft the petition, my lord. As such, the delay has been explained, and my lord will consider that substantial justice may follow, my lord. Regarding the technicality, my lord, that may be looked after by this court by striking off the petitioner number 2 and 3. Because anyways, I am protected under Order 41 Rule 3 or Rule 4, my lord, because any one of the appellants may challenge the decree, my lord. Since appeal is not there and I'm come under revision, my lord, that I'll take the benefit of that order, my lord. Order 41 Rule 3, my lord. That is my humble submission, and my lord, substantial justice may be done, my lord. The CRP may be dealt with. This is delay of only 208 days, my lord, not like 1200 days or something like that. Not a substance. I mean, as such, my humble submission is that the delay may be condoned and the CRP may be taken up, my lord, and decided on merits, my lord. It was a suit for preemption, my lord. And preemption, there is a certain order 41, order 20, rule 14, there's certain directions which have to be followed by the court, which was not done. But not going into the merits, my
Mr.
lord.
Bora, you see earlier, one legal aid counsel was engaged by the Legal Services Authority. But the said legal aid counsel has returned the file to the authority. Thereafter, Mr. Borua was engaged.
My lord, kindly, I am also referring to the annexer 2 of their application.
Annexer?
Annexer 2.
Hmm. Yes.
So at page 12. So
Hmm.
this is from Gauhati High Court Legal Services Committee Principals in Gauhati
Hmm.
to some Proceedings Barua on dated 28th June 2024. Now, about his engagement, there is no any document. So he can put any date.
I am Prosecutor.
So he is Prosecutor Barua. Then how can he say that he was engaged on 16/7, not on 28th June?
No, no, my lord.
Then how much time he consumed in preparing and drafting it out? That is also nowhere explained, my lord.
No, my lord, this is the letter of assignment, my lord. I have been assigned,
Basic ingredient
but-
will be there
but the
for
brief has been handed over to me on
consideration.
16/7.
Even while dealing with an application for limitation also, my lord.
My lord, that's
The
why,
starting point,
One by one.
yes, sorry, my lord. My lord, that's why the legal aid record was called for, my lord,
Hmm.
to ascertain whether I had been assigned the brief on this date or not, my lord.
Hmm.
The legal aid record was called for, my lord, on the previous occasion,
28/4, my lord, order.
28/4/25, my lord.
28/4/25.
Hmm.
Second paragraph, my lord.
Annexure 2 is the, my lord, letter of assignment. A
Hmm.
case is allotted to a particular council,
Hmm.
but the handing over of the brief is subsequent, takes place subsequent to that, my lord.
Hmm.
That is the mode of operation going, I mean, which is prevalent now in the legal service authority.
So, we will hear the civil revision petition on merit. Let the delay be conducted.
My objection will be. My
Okay, yes, yes. Definitely we will record your submission. Heard Mr. Borwa, learned counsel for the applicant. And also heard Mr. Bora, learned counsel for the respondent, opposite party. This application under Section 5 of the Limitation Act is preferred by the applicant. For condonation of delay of 208 days in filing connected civil revision petition. Against the order dated 13/12/2023 passed by the learned civil judge Junior Division number 2 Nagaon in title execution case number 23 of 2014. It is to be noted here that by the impugned order dated 13/12/2023, the learned executing court has dismissed the execution petition. Mr. Borua, learned counsel for the applicant submits that earlier the legal service authority has engaged one counsel to pursue the case of the applicant, but the said counsel has returned the file on 27/6/2024. And only thereafter, the Legal Services Authority has engaged him and handed over the brief to him on 16/7/2024. And thereafter, he has prepared the petition and filed the same on which that you have filed a revision petition,
My lord, 22/10/2024,
22
10/2024.
22/10/2024, and in the process there was delay of 208 days, and he submits that the delay is not intentional, rather it is circumstantial, and he has a no, and the applicant has a case to be heard on merit, and in the paragraph number 2, 3, and 4, the cause of delay has been explained, not sufficiently explained, and therefore Mr. Borua has contended to allow this application. Per contra, Mr. Bora, learned counsel for the respondent opposite party, has vehemently opposed the petition. Mr. Bora submits that the execution case filed by the petitioner, filed by the applicant herein, being execution case number 23 of 2014, has been dismissed by order dated 13/12/2023, and that the present application is filed by 3 applicants, but only one applicant, namely Sri Tulan Sando Bora, has applied for legal aid, and there is no explanation as to why the other 2 applicants remain silent for 208 days. 208 days. And that the delay has not been properly explained, and under such circumstances, Mr. Bora has contended to dismiss the petition. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the documents placed on record, and also the explanation for delay being put forwarded in paragraph number 2 and 3 of the application. 2, 3, and 4 of the application. Then it appears from the statement and environment made in the paragraph number 2 that after dismissal of the execution petition, certified copy was applied for, and the same was handed over on 3/1/2024. And on receipt of the certified copy, the applicant number 1 applied to the High Court Legal Services Authority for availing the legal aid service. And thereafter, one counsel was engaged, but the said legal aid counsel has returned the brief to the Legal Services Authority, and only thereafter the present counsel was engaged by the Legal Services Authority on 16/7/2024. The explanation so put forward by the applicant in paragraph number 2 and 3 seems to be justified and reasonable, and to the considered opinion of this court, the delay of 208 days in preparing the civil revision petition stands sufficiently explained, and in that view of the matter, this court is inclined to allow this application. The delay of 208 days in preparing the connected civil revision petition stands condoned. In view of the order passed in the IA Now the registry will register the civil revision petition and list the same before the court as soon as practicable.
Obligement.
Turning item 22.
Pardon?
I was on break.
Okay, all right. Madam, you see, here, one execution case has been filed against the superintendent of police, Hailakandi.
Yes.
And the executing court has directed personal appearance of the SP before the executing court. The contention of the petitioner is that he has written several letters to the authority for sanctioning the amount, but he has received no response.
From SP.
No, from the
Inspector General of Police.
Inspector General of Police. Can you obtain an instruction as to what is this, those letters are pending? We'll take it up at 2 o'clock. We'll take it up at 2 o'clock.
It is from Lordship.
Hailakandi. No, you have to obtain instruction from the office of the Inspector General of Police, Gauhati, Gauhati, not from Hailakandi.
To take from the Hailakandi Lordship. That's why Lordship is on Monday Lordship.
Monday, when the next date is?
7th, my lord, Saturday, my lord, 7th.
Saturday. Can we fix it tomorrow then? Tomorrow. Okay. Heard, Mr. Das learned counsel for the petitioner and also
May Lordship decided at 10 to or 26. That instruction Lordship is on 10 to.
yes, we has produced some letters written by the SP.
Yes, Lordship. On 10.
Sir, Das, do you have some copies of these documents?
But I'll serve a copy, man.
Furnish to her so that
Yes,
she
yes.
may obtain instruction. Piccolo. This civil revision petition is directed against the order dated 28/5/2025 passed by the learned civil judge senior division Hailakandi in money execution case number 1 of 2025.
Government
During the course of hearing, Mr. Das has produced some letters written by the judgment debtor to the Assistant Inspector General of Police Administration Assam, Gauhati. Requesting necessary financial sanction of the decretal amount in favor of the petitioner hearing. Petitioner hearing. And Ms. Borman, learned additional senior government advocate who is present in the court, is requested to obtain the present status of the letter dated 7/1/2026 and also of the letter dated 10/2/2026 and apprise this court tomorrow by 2 p.m. Tomorrow at 2 p.m. Yes, it's a list the matter as such. Huh? Copy letter.
Number 6.
Please, your lordship, my lord, service is complete, my lord. Respondent number 1 has appeared and respondent 2 has also appeared, my lord.
Service complete.
Service complete, my lord. LC has been received, my lord.
So we'll list the matter for hearing.
Hearing, my lord.
Lordship, may I
In this case, Lordship, their title appeal was dismissed as their condemnation petition was rejected. So there are some development in title execution case since 2019. May I pray to call for the record of title execution case, Lordship? They have already prepared two CRP before this Honorable High Court, and we have also prepared two CRP, Lordship. Those documents are available only in the title execution proceeding, Lordship. After.
No, you produce certified copies of those documents.
Normally, in regular second appeal, there is no provision to file affidavit in opposition. If your
No, not necessary. You produce certified copies.
Lordship, the record will help in deciding the regular second appeal, Lordship. So, if possible, Lordship.
Record was earlier not called for.
Record call for Lordship from the title suit and title appeal. But they are pursuing the title execution since from the very beginning, Lordship. In the title execution, they are the administrator Lordship filed several objections and they are brought into before this board by way of filing civil revision also, Lordship. So.
No, this regular second appeal is against the judgment and decree passed by the first appellate court,
Yes, Lordship.
not against the title execution case.
They have filed one title appeal, Lordship, along with the condemnation application before the first appellate court. After
You
pursuing.
produce the certified copies of those documents.
Lordship, then Lordship, I may be allowed to file my affidavit in opposition, Lordship. By way of an affidavit in opposition, I will bring all those developments, Lordship, before this court.
Pardon me, sir.
VK Borwa, my lord.
Learned counsel for the appellant and Ms. Sodori, learned counsel for the respondent. It is submitted at the bar that you are respondent number two. It is submitted at the bar that this matter service has been completed and the LCR has also been received. And as such, the matter may be listed for hearing. Accordingly, it is provided that Resolution shall list the matter for hearing in usual course.
Lordship,
Ms. Chaudhary, learned counsel for the respondent number one submits that she may be permitted to bring on record some of the documents relating to title execution case number
10/2019.
10 of 2019.
Honorable Munsif Hatsing Mari, Lordship. Before the Honorable Munsif Hatsing Mari.
Pending before the court of learned civil judge,
Lordship, Civil Judge Junior Division.
civil judge junior division, Hatsing.
Hatsing Mari, Lordship. South.
They are allowed.
May I pray to list this matter on second of
The
April?
second little difficulty, but after vivification, my lord.
No, this is of 25 matter. In usual course, the rest they will list it.
Only regarding condemnation, Lordship. Otherwise, their condemnation application was rejected, Lordship.
After vivi.
21st April.
28 April.
Obliged, Lordship.
I'll-
Order number 23.
Lordship, clause list reflected the name of the respondent advocate, Lordship. But as per the office note, Lordship, the
Service completed.
service, as per office note, Lordship, the service is not completed, but the Youngest Council has
Incomplete
already
in
filed
address.
the Wakalatnama as per office note.
Pardon?
On behalf of respondent, council has already
Appeared.
filed Wakalatnama, Lordship.
When?
Office note, Lordship, may kindly see the office note.
Okay. Okay. Heard Mr. A. Islam, learned counsel for the petitioner. None appears for the respondent on call, though as per office note dated 2/3/2026, when council has entered appearance by filing Wakalatnama on 4/12/2025. Rest shall list the matter on sorted
On 18 March.
18th of March. 18th of March, in the column, admission.
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 Obviously.
For admission. As number one, pardon me.
May please also, my lord. The other side was asked to bring certain clarification. The
Yes.
other side was asked to, government was asked to bring certain clarification, my lord, as to the rule, amended rule of the 2005. Because my case has been, your lordship has already heard, that I was selected in 1999. And there is dispute regarding two lists. And ultimately, this court as well as the government also accepted that my selection was valid. But they appointed me as tutor. Now I am continuing as tutor. But my plea is that, my lord, my appointment precedes the 2005 amendment, and as such, those requirements of B.Ed or BT was not there. So on that point, the government advocate was asked to get the clarification.
Yes, Mr. Sharma, the relevant file is available with you.
We have filed two affidavits.
Mm.
One was filed lordship. Page number 55.
Mm.
Page number 55 was the first affidavit, wherein we have stated our stand also. Filed by the director also. Also, we have page number 56, paragraph number 5. That's also.
Yes.
Paragraph number 5 also.
Mm.
That page number 56, that the different states that as reported by the district elementary education officer Karimganj by letter dated 1/6/2023, the advertisement was issued, but the petitioner was not selected. This selected list subsequently we have gotten record by way of an affidavit, even on the last of the lordship has produced the original record also.
Mm.
As per Honorable Court's order dated 15/12/2013, passed in WPC number so, the case of the petitioner was placed before the expert committee for consideration of her claim for payment of salary. Thereafter, the government verified the records and after verification, issued an order dated 18/7/2013, stating that the name of the petitioner did not appear in the proper select list dated 27/10/1999. This select list was the actual select list, wherein the name of the petitioner was not there, which I have placed before the Honorable Court by way of an affidavit, subsequent affidavit.
Mm.
And the original record was also produced on the last occasion,
Mm.
which was approved by the sub-divisional level advisory board Karimganj. The select list which has been obtained by the petitioner is not valid select list. The petitioner submitted a review petition dated 13/8/2013, which was rejected by the government by order dated 26/9/2013.
Mm.
Subsequently, para 6, that the DO Karimganj has further reported that the petitioner obtained the select list from one Kamal Datta, who is not the official authority. In paragraph 19 of the writ petition, the petitioner also states that he obtained the select list dated 27/10/1999 for 111 numbers of candidates through RTI from Sri Samal Datta. It is to be mentioned that the directorate has issued a direction to the deputy director of the school Karimganj to file a FIR and criminal case on the charge of fraud and forgery against the said Samal Datta. Petitioner in WPC number 203 of 2010 by order dated 17/6/2016. The name of the petitioner was in the list dated 13/11/1999,
Mm.
which has no valid original document. The list where the petitioner claims to have 13/11/1999. So the appointment of the petitioner was found illegal, as the petitioner name is not enlisted in the valid select list as per government order dated 18/7/2013. The petitioner is not entitled to arrear salary as claimed. The Honorable Court by the order dated 12/3/2020 passed in WPC number 5094/2013 directed the authority to
re-examined. Again, it was re-examined. The claim of the petitioner in the light of the select list produced by the petitioner. And to make another verification as to whether the name of the petitioner finds place in the select list dated 27/10/1999. The honorable court further directed that if the name of the petitioner is found to be included in the said select list, the petitioner will be entitled to be declared as validly appointed teacher. And she shall be entitled to all the consequential benefits, including the area and current salary. If her name appears in the select list of 27/10/1999. However, on verification, it was found that the name of the petitioner did not figure in the said valid select list dated 27/10/1999. And therefore, the petitioner is not entitled to any benefit. So, paragraph number, paragraph number 8. The deponent states that the petitioner was categorized as illegal, irregular teacher, and after screening process, the petitioner was subject to screening process also. She was newly accommodated as tutor by order dated 30/1/2021, issued by the directorate. In the said order, it is mentioned that the accommodated tutor will get the prospective effects from 1/11/2020, and he has claim any benefit whatsoever in respect of the service rendered by him or her prior to 1/11/2020. Therefore, this the petitioner was subsequently accommodated as tutor, with prospective effect from 1/11/2020. Now, Lordship, subsequently, you will find another affidavit, Lordship. Affidavit dated 14th of May 2025, wherein the select list, the original select list dated 27/10/1990 was annexed. And this select list, Lordship, where the name of the petitioner appears.
But the original copy of the select list is not available with you. This is only the
Lordship,
Xerox copy.
the signed attested by the concerned authorities. That I have produced before last occasion. Now, Lordship, may I take a Lordship to the. Now, the petitioner has been accommodated as tutor. Now, may I take a Lordship to the prayer portion of the petition? Here, that said accommodation order is not under challenge, Lordship. This accommodation order with proscription effect has not been challenged. The prayer, Lordship, may kindly. Lordship.
No, here the prayer is for regularization of service and for payment of the salary
Prayer is for regularization of service.
and salary, payment of salary. Yes.
There is no challenge as regard to the accommodation order. He has, the accommodation order has been duly
No, is it
accepted.
necessary to challenge the accommodation order?
No, otherwise, the Lordship, the petitioner has already accepted the accommodation order. He has joined.
Maybe. There may be one column that she will not hesitate against the
Lordship, kindly,
accommodation order.
Page number 50.
Page number?
Page number, I'm sorry, page number 54, annex 50.
Page number 54.
Lordship,
Yes.
after this table, Lordship, the Karimganj, lovely that's thereafter the Lordship. Fourth line, Lordship. The accommodated tutor will get the prospective effect from 1/11/2020 only. Then he or she cannot claim any benefit whatsoever in respect of past services rendered by him or her prior to 1/11/2023. 2020. Therefore, this condition has been duly accepted by the petitioner and regarded.
So your second contention is that since he has appointed, no, he has accepted this accommodation by signing a bond.
Board lordship, I will, there is a condition also. This condition has been duly accepted. My submission is that this condition which was given in the order of accommodation has been duly accepted by the petitioner. And after accepting the terms and conditions here, written herein, the petitioner has joined and working as a tutor lordship. This condition has not been challenged, lordship.
Okay. Yeah, so Mr. Sharma, any reply?
Yes, my lord, I will reply. My lord, Mr. P.N. Sharma is arguing against the order of this court, my lord, page 43, annex 13.
Page 40?
Yes, because this case is a very checkered history, my lord, since 99, continuing. The lady is working, and that has been also admitted in the case 54, which Mr. Sharma has read, that the tutor appointment dated 30th of January 2021, and it is said prospective, but they have said in that letter, my lord, that she will not be entitled to any salary, prior to the date of her new appointment, for which the period she was working. That means she was working, they admit. They have not denied that she was not working at all. Once you allow a person to work, you must pay the wages. That is the theory of law, all settled by different courts and the honorable Supreme Court. Now I'll also kindly come to page 43.
Yes.
That is the judgments of this court, my lord.
Page 43.
3 and
Okay.
relevant portion, relevant paragraph, I am reading by page 45, paragraph 4. Because the dispute, my lord, about on two select lists. One is 27/10/1999, that is the original, and then another fake one, 11 fake one, 13/11/1999. So my name figures in the original list. They have been denying continuously. Ultimately, after on this point, this court has already held, my lord, that paragraph 5 onwards. On the other hand, London Council of Petition has drawn attention of this court to Annexure 7, which is said to be select list dated 27/10/1999. But they couldn't produce the original list, my lord, which they claim to be original, which was also referred to by the committee and reflected in the impugned order dated 18/7/2013. In the said select list, the produced by the petitioner, copy which is Annex 7, the name of the petitioner finds place in serial number 35 under the interview number unreserved 1538, and the petitioner has been recommended against the vacancy which was earlier held by one Sandhya Rani Day, number 911991A, Navin Vidyapit. The said select list is signed by the Deputy Inspector of Schools, Karimganj, and is said to be verified by the Superintendent of the Director of Elementary Education, Assam. The petitioner has also been drawn attention of this court to the select list dated 13/11/99, which has been held to be invalid by the committee, as reflected in the impugned order dated 18/7/2013, in which the name of the petitioner does not appear, does not figure. Thus, from the above, what is seen is that while authorities have given the finding as referred in the implement order it is so and so, that the petitioner name does not figure in the valid select list that is so and so. The petitioner has been able to show at a list said to be the select list of 2710 to 1999, supported by affidavit that her name indeed appears as serial number 35 of the said list. Thus, from the above, what is clearly evident is that the finding of the committee that the select list dated 2710 does not include the name of the petitioner and the protection of this list by the petitioner in this petition, in which the name of the petitioner is included in the select list that so and so, is within the realm of ascertainment of facts. As such, this court of, for obvious reasons, cannot undertake this exercise to ascertain the correctness of the either of the claims. However, since the petition has been able to show certain documents supported by affidavit, this court would direct the respondent authorities to examine the claim of the petitioner in the light of the select list produced by the petitioner in this petition and make another verification as to whether the name of the petitioner finds place in the select list dated 2710. It goes without saying that there is already a finding of the authorities that the select list dated 2710 is valid and the name of the petitioner is found to be included in the list, select list, as claimed by the petitioner on the strength of the documents relied upon in this petition or any other document as may be available. The petitioner would be entitled to be declared as a validly appointed teacher and shall be also entitled to all the consequential benefits including arrear and current pay, salary for the for which the respondent authors will undertake fresh verification process as directed above and also inform the result to the sons of the petitioner. So, my lord, this is the order of this court. Now, thereafter, my lord, they have passed the order at page 15, my lord, annex 15, page 54. If her appointment, if your selection itself is bad, then there is no question of appointing her as a tutor or whatever it is. That means they ultimately accepted that her selection was valid and they had to appoint her. Otherwise, they would directly reject. No, we verified on the order of the instinct of the order of the High Court, and she does not figure at all. There is no such figure of this order. They directly issue appointment order as tutor. Tutor, under the rules, my lord also knows, tutor can be appointed for one person, for a person who doesn't have the BA degree or DLED degree. So at that time, there is no amendment to the rules. Rule 1977 rules, my lord. I'll show. Well, it will kitab asam 293. 293 page number. That was the point last time I argued, and that was the point your lords were asked them to clarify on the legal point. The video was already read there also, now also.
Page number?
In my book, it is 293. Assam Elementary Education Provincial Rules 1977. There is still valid in the book, my lord, as well as the act on which this rule was made. There are many other act passed, but this remains. 293. Yes, Lordship, my lord. Yes, Lordship. Now, your Lordship will directly come to this rule was made, my lord, under the 1977 Act. It is statute rules, my lord. Your Lordship, see 293. In exercise the powers conferred by the provisions of the Constitution of India, as well as the 1974 Act, Assam Elementary Education Provincial Act 1974. You will also kindly now come to the Rule 3, Method of Recruitment. That having complied matter, Rule 3 is complied, selection has to face that there would be a replacement and selection would be held, and I have selected. Now you will also kindly come to page, my lord, the relevant portion 296, age and qualification.
Yes.
Clause 3. It is clause 3 under Rule 9, Rule 3, my lord, method agreement. Minimum qualification of a person to be eligible for appointment as a teacher in elementary school shall be as per the notification issued by the state government from time to time in conformity with the NCT norms. These qualifications shall be applicable to all category of elementary schools. In case of any relaxation required in respect of any qualification as prescribed by the NCT from time to time, the state government shall make up the matter with the government of India for such relaxation. Now, we'll also kindly below, just in 296 itself, below note number, first note. This rule got amended, my lord, on 10/11/2005. And it was the rule I have read has substituted these old rules. Clause 3 was earlier substituted by so and so. AAC number 153/2005, part 74, dated 10th November 2005 and published in the Assam Gazette Extraordinary number 351, dated 10/11/2005, which was from 10/11 before the 10/11 before the substituted read as follows. Earlier the qualification matriculation shall be the minimum qualification for the post of teacher in elementary school. So this was amended, my lord. Constituted by the 2005 amendment. So before 2005, I need to be just matriculate. No DLED, no DLED system was not there, no BEd, no BT. So since I have been appointed regularly now my claim is my appointment is valid, and that's why my selection was valid. That's why you are bound to appoint me, though very lately. So I am to be regularized in the regular post, not in the tutor. As per my qualification has covered the qualification prescribed then, which came to amended only in 2005. In 99, the matriculation was the necessary qualification. This is my argument.
Okay.
Yes.
Mr. R.P. Sharma, learned senior counsel, assisted by Mr. A. Rosik, learned counsel for the petitioner, Mr. P.N. Sharma, learned standing counsel for the education department. Argument concluded. Judgment reserved.
Item for hearing on
JB, my lord.
Chief.
number 4.
May I please, your lordship? My lord, this is a regular second appeal, my lord. Filed under sections 100 of CPC. My lord, what has happened in this case? The appellant before your lordship is the plaintiff before the learned trial court. My lord, the plaintiff filed a suit for specific performance of contract on the basis of a, my lord, agreement for sale of land. my lord, the learned trial judge dismissed my suit on the ground, my lord, that the agreement in question, my lord, is unregistered.
Civil
Now, my
Judge
lord,
Junior Division has dismissed the suit.
Suit on the ground, my lord,
The deed
that
was unregistered.
the agreement for sale, which was executed by me with the, my lord, defendant number 1, the landowner. I am the prospective purchaser, my lord, in the agreement. And my lord, defendant number 1 is the owner of the land. We, my lord, he executed an agreement that was, of course, my lord, unregistered. The learned trial judge says, my lord, since it is unregistered, my lord, the suit is liable to be dismissed. But with all respect, my lord, this is my the learned trial judge, my lord, has overlooked the provisions of law, my lord, section 49 of the Indian Registration Act, my lord, section 17A of the Indian Registration Act, as well as, my lord, the recent judgment of the apex court, my lord, wherein the Honorable Supreme Court has said, my lord, that unregistered document for sale of land is permissible in evidence in a suit under, my lord, specific relief act.
Where is that decision?
My lord, that decision, of course, my lord, is not with me, my lord. Is, my lord, a recent decision, my lord. SLP number 10893 of 2021. Mardu Yandan versus Munniyadi and legal heirs. My lord, I'll place this judgment, my lord, within a short while. Now,
Within
my-
a short means
my-
today.
today itself, my lord, yes. Well, first of all, your lordship would kindly see, my lord, section 49 of the
Registration Act.
My lord, Registration Act. Has your lordship got it, my lord? Lordship may kindly see, my lord, the proviso, provided that an unregistered document affecting immovable property and required by this act or transfer of property act to be registered may be received in evidence of a contract in a suit for specific performance under chapter 2 of Specific Relief Act 1870. The learned trial judge has overlooked, with all respect, my lord, these particular provisions of law. My lord, that.
Okay, you produce that judgment of the Supreme Court.
My lord, it is coming, my lord. It is. I'll giving it, my lord, within a short while. This is one aspect, my lord. Second, my lord, section 10 of the Contract Act, my lord. Your lordship kindly see, my lord, section 10 of the Contract Act.
Section 10.
My lord. All agreements, has your lordship got it, my lord?
Got it.
All agreements are contracts if they are made by a free consent of the parties competent to contract for lawful consideration and with lawful object, and are not hereby expressly declared to be void. Nothing in this hearing shall take affect the law in force and not hereby expressly reflect the contract. So, my lord, it has to be by way of free will. My lord, without any question, without any influence, that is, my lord, if the agreement is, my lord, made without any coercion, without any undue influence, my lord, it is valid in the eye of law, unless it is expressly void, my lord. This is what section 10 of the Contract Act says, my lord. Now, my lord, this defendant number 1, against whom, my lord, my basic grievance is, my lord, he did not contest the suit, despite service of summon, my lord.
Defendant number?
1. Defendant number 1, my lord, to whom I have made an agreement for purchasing of land. Now, my lord, he did not come forward. He did not file this written statement, my lord. Therefore,
So,
the law says, my lord.
Court proceeded ex parte against him.
Yes, court proceeded ex parte, my lord, because despite service of summon, my lord, he did not appear. Now, my lord, your lordship kindly see Order 8, Rule 5 of CPC, my lord. But I am only on the point of law, my lord. How, my lord, the learned courts below has committed error, my lord, while ignoring the provisions of law.
Order 8, Rule 5.
Order 8, Rule 5, my lord. Your lordship kindly see, my lord.
Specific denial.
My lord, specific denial, Order 8, Rule 5, subclause 1, every allegation of fact in the plaint, I'm sorry, if not denied specifically or by necessary implication, is stated to be not admitted.
Mr. Sen, the defendant number 1 did not contest the suit.
My lord,
What is the question of specific denial by him?
meaning thereby the contents that has been stated in the plaint is admitted under Order 8, Rule 5 of the CPC, my lord. That is my contention. The moment defendant does not appear, my lord, did not file any written statement, it can be presumed that the statement made in plaint, my lord, has not been controverted, thereby admitted. If it is admitted, my lord, then, my lord, the decree could be passed. My lord, your lordship kindly see. Then, my lord, shall be taken to be admitted except in against the person's inability, provided that the description where the defendant is not failed, it is not probable. My lord, here, my lord, is a case where the defendant did not file any written statement. Therefore, my lord, my respectful submission would be, my lord, that whatever we have stated in our plaint is my lord, admitted in evidence. Now, Lord, these provisions of law, Order 8, Rule 5, has also been, my lord, ignored by the learned trial judge.
Then who contested the case?
Defendant number 2. Defendant number 2
Who
is, my lord,
who is the defendant number 2?
defendant number 2 is a person, my lord, he said, my lord, that he has, my lord, some dispute with the defendant number 1. Defendant number 2 has filed a suit against defendant number 1. Defendant number 1 also filed a suit against defendant number 2, my lord, and there are multiple litigations in between them. Therefore, my lord, we as a formal party, my lord, implemented the defendant number 2. But I have no grievance against the defendant number 2. Now, the learned trial judge, my lord, only on the basis of the evidence and materials on the basis of defendant number 2 and saying that, my lord, my agreement is unregistered and dismiss the suit. Now, my lord, I have, my lord, formulated some substantial question of law.
Okay,
lord-
I have seen it in the memo of appeal.
My lord,
Okay, we'll pass the order. You give the judgment of Supreme Court.
my lord.
Okay.
Lordship, kindly have a, my lord, 5 minutes.
No, not necessary.
My lord.
It is already there. I
Yes.
have gone through it.
My lord, page 10 of the, my lord, for a second, my lord. Page 10 of the memo of appeal, my lord.
Mm.
I'm sorry, page 6, my lord. Page
Yes,
6,
I have seen all those substantial question of
My
law
lord.
suggested by you.
my lord.
We'll
This
see
one-
which one will be.
All these are, my lord, on point of law. My lord, learned trial judge says unregistered document,
Mm.
which is, my lord, absolutely, my lord, not in accordance with the law. Unregistered document is permissible when it is a suit for specific performance of work. Number 2, my lord, learned appellate court, my lord, has said, my lord, on one hand, that the learned trial judge has failed into error, my lord, as saying that it is an unregistered document, and my lord, dismiss the suit on the basis of relying the evidence of defendant number 2. My lord, one hand he is, my lord, rejecting the judgment passed by the learned trial judge. Otherwise, my lord, affirming the judgment, my lord, on the other hand, affirming the judgment of the. So, self-contradictory, my lord, judgment passed by the learned first appellate court. That is my respectful submission. My lord, I will submit the subsequent court judgment.
We'll
I am
resume
deeply
after
obliged.
5 minutes.
I am deeply obliged.
Item for hearing, item number 8, part of it.
My lord, I'm appearing for Mr. A. Sattar, my lord.
Pardon?
I'm appearing for Mr. A. Sattar, my lord.
Ace?
A. Sattar.
Okay.
Abdul Sattar, my lord. He has informed me that he's not well, my lord. This is a part-heard matter, my lord.
Yes.
He has made a request, my lord. He's not well, my lord. So he has requested for an accommodation today, my lord. If it can be taken up on 31st of March, my lord. It's a hearing day, my lord.
Okay. Suggest that date.
31st of March. my lord.
30?
31st of March.
31st of March. Okay. Mr. Your name, please?
Z. Mukit.
Learned counsel appearing on behalf of Mr. A. Sutter. Learned conducting counsel for the appellant submits that Mr. Sutter is indisposed of and he prays for listening the matter on 31st of March. The pair, having not been opposed by Mr. A.C. Sharma, learned senior counsel, assisted by Mr. Z. Vardas, learned counsel for the respondent. The matter stands adjourned to be listed on 31st of March as part heard.
Obliged.
Item numbers 10, 11.
May please your lordship. Both the cases I am lead by senior advocate Mr. P.S. Deka, lordship. He is lacks in some other court. May I pray some other day, lordship, can you take up both the matters, lordship? My line senior is there. Any other day, lordship.
Okay. 31st.
March.
As agreed by learned advocates of both the parties, list this two civil revision petition on 31st of March 2026.
Obliged.
Item number 14.
Pardon? Okay. Yes, Mr. Sutter is absent here also.
He's absent, my lord, but he had given me the brief, my lord, because on the last occasion we sought for an adjournment. So if your lordship accommodates, my lord, then it is okay. But otherwise, in the last order, we have
No,
been given the
whether
last.
the other side will agree or not, I don't know. Okay, after some time.
My lord.
Item 15.
May I please your lordship? I am
Yes.
appearing on behalf of Mr. A. Tiwari. As he is severely unwell and is suffering for fever, can you fix a matter in the coming week?
When?
In the coming week, if it's
Coming
possible.
week. Miss, your name, please?
Miss M. Chandalia.
M.
Chandalia.
Learned counsel for the learned counsel appearing on behalf of Mr. A. Tiwari, learned conducting counsel for the petitioner. Press for listing the matter in the next week. Pair allowed. None appears for the respondent on call. List the matter in the next week.
Paragraph 16 and 17.
Lordship, in this matter, my senior MK Chaudhary is on legs, Lordship. If your Lordship can.
MK Chaudhary.
Yes, Lordship. If your Lordship can kindly pass over the matter for the time being, Lordship.
But the appellant side is also absent.
Yes, Lordship.
What to do? You are for the respondent.
Yes.
Appellant, I know.
Lordship, my senior is on the way. Can it get passed over for the time? Paragraph 19. 18, sorry. 18.
Senior is on leg, my lord. Can you add 2, my lord?
Two. You are for the appellant.
Appellant.
Who is for the respondent?
Sir, Dr. P.K. Goswami is appearing, my lord.
Who?
Dr. P.K. Goswami. My lord.
Is he present in the court?
I have no idea, man.
Okay, after some time.
Paragraph 19.
Your Lordship, I'm appearing for the respondent.
Appellant.
Your Lordship,
This is civil revision petition. You cannot be for the appellant.
Sorry.
Yes.
Your Lordship, the currently engaged counsel has recently been appointed as APP. So we cannot, we need time to. Engage
Who is the conducting counsel?
Your Honor, Mr. S. Sahu.
S.
Sahu.
S. Sahu.
Yes, sir.
He is appointed as?
Assistant Public Prosecutor.
Okay. Now what to do?
Your Lordship, I'm praying for 4 weeks' time that we can engage counsel.
Yes.
No.
Heard means your name, please?
M. Borua Bhuya. Interim
We are learned counsel for the learned counsel appearing for?
petitioner.
You are appearing for?
Petitioner M.K. Sharma.
M.K. Sharma, learned conducting counsel for the petitioner, and Mr.
Interim order may pass earlier. May continue.
Your name, please?
B. Singh.
B. B.
Singh.
Learned counsel appearing on behalf of Mr. S. Sahu.
Yes, sir.
Learned counsel for the respondent, conducting counsel for the respondent. The learned conducting counsel. No, learned counsel appearing on behalf of Sir S. Sahu, learned conducting counsel for the respondent submits that Mr. Sahu has been appointed as assistant public prosecutor, and the respondent need some time to engage another counsel to conduct the case, and press for listing the matter after 4 weeks. They are allowed. Interim order pass earlier shall continue. Rest shall list the matter after 4 weeks.
Paragraph 25.
None appears for the appellant on call, and also none appears for the respondent on call. List the matter after 1 week. In the event of subsequent non-representation of the parties,
appropriate order shall follow.
Calling item. And 17.
May it please your lordship. These are two cross appeals, my lord, against the same judgment. There were several issues. Some findings are in my favor. One finding is against me that I have come up in appeal. And the respondent side has come up against the findings against the issues decided against them, my lord. It's a long matter. It will take some time, my lord. Today I am not 100% prepared with the brief, my lord. Can it be taken up on some other day?
Okay, no problem.
It's a rare appeal. Any convenient date, my lord.
Yes.
I have no objection if my non-friend argues fine, my lord. If he has got difficulty, let it be another day. It will take some time, my lord.
It will take some time.
Quite some time, in fact.
Okay. As agreed by learned advocates about the parties, let us analyze the matter on suggested date.
The 24th or 26th today.
April first week.
April 1st week more difficulty.
26 is a Thursday.
26th, no difficulty.
26 is
Oh, 26th, 31st, 25th, mana 31st. 31st.
31st of March.
31st of March.
Okay.
I am aware.
Calling item 18. Calling item 16.
Into material.
Calling item 14.
My lord, can it be on the same date, 31st one? What?
দুটা কেস আছে এইটো আছে আৰু এটা আছে
Itu
আমি ওয়েট কৰিছো
itu বন্ধ।
আপনার 18 18 to time লৈছে
Itu PK Swami nade karo।
অলরেডি মাত্রা করব যদি 15 মিনিট ওয়েট করব না লাগে না অর্ডার টেকি না লাগে এখানে টাইম লব আর না মিনিট টেকি
Itu matter। Heard, Mr.
Z Mukit, man.
Learned counsel for the appellant. And also heard, Miss
NM Longke on behalf of PK.
Ellen,
NM Longke,
learned counsel appearing on behalf of Mr.
PK Deka.
PK Dekka. Learned counsel for the respondent. Learned counsel for the respondent. As agreed by learned advocates of both the parties, recessal lays the matter on 31st of March.
Right.
31st of March.
Well, public.
Okay.
Maybe taken up after a break, my lord. I have contacted the other side, my lord. She will also be available after the break, my lord.
After the break.
After the break, my lord.
Okay.
Once more.
Land revenue control to us. Okay, pilot. Revenue manual. Yes, my lord. May it please your lordship. My lord, here I am the defendant number one, my lord. Defendant. in the trial court. Here, although the defendant number 1 died, he has been substituted by his legal heir, son and daughter. My lord, what has happened, my lord? There was a plaint by the respondents, my lord, seeking that they are in tenancy under the Assam Temporary Tenancy Act. That their claim is that they have they have been threatened to be evicted by the defendant without following the due procedure of law, so they should be protected. And these plaintiffs are basically, they say that from their predecessors, they are having possessory right, that of the possession and use, in dint of being having quotients under the Assam Temporary Settled Areas Tenancy Act 1971. Thereafter, the defendant, the present appellant, contested the case and filed a written statement along with a counterclaim. Our specific advertisements and our submission, our ground in the trial court was that we are the absolute owner. We have disputed the tenancy as far as it doesn't go against the records. In this particular case, it is admitted position that tenant, this respondent 1, 2, 3, 4, 5, and 10 have some right of tenancy. They have been tenants since my father's days, and after my father's death, they have been tenant under the present appellant. What has happened, Your Honor, my lord, that from 2000, since 2012, on the even on the plaint, it is an admitted fact that they were paying rent in kind. That is 1/5 of the crops grown out of the said land. That is their admitted position, that they were tenants and they were paying rents. And our specific plea was that since 2012, they have avoided to pay us the rent in this and that pretext. And 2012 we are passing, and 2016 we have initiated the proceedings. Now, my lord will kindly say, that point of time, two DWs were examined, DW1 and DW2, by the defendant himself and one another, his clerk, and both of them have contributed each other. They have their plea is that we have went to collect rent, but they refused to pay the rent. Now, in the trial court, it was held that they have khatians, and so they have the right to use the land, and we could not properly establish that rent was not paid to us. Defendant in the trial court has failed that the rents were paid on time, but that we have not received rent. So onus would, according to the trial court below, learned court below, onus would be on me to prove that I am not receiving the rent. That was there. That is one point. Yes, that is where this whole thing.
What is the legal position?
Legal provision, that is where it is very clear.
Lies upon whom?
Legal provision is very.
The tenant.
Tenant has always, they have to ask for a receipt from the landlord. They have to maintain. This is specific. My lord, I'll come to that. Basic question of law. In the trial court has holded that appellate court, first appellate court modified little bit, said 6, 7, 8, 9 have worked out of the that proceeding. So only the case should be against 1, 2, 3, 4, 5, and 10. And it was held that yes, the defendant number one, who is the present appellant, is the owner of the land. There is no dispute. Title remains with me, but the right to possession and to inherit, this will remain with the present respondents, that is the plaintiffs. Now we have framed particularly one question as substantial question of law, that is whether in a tenancy, if it is a default on part of the tenant, whether they are liable to be evicted. This is the substantial question, one of the substantial question. Now, my lord, I will just show from the legal provisions, section 50 of the Assam Temporary Settled Areas Tenancy Act 1971. Grounds of ejectment, 51. Section 51 of Assam Temporary Settled Areas Tenancy Act, 51.
Yes.
It says grounds of ejectment. C, in subpara 2, C, that he has failed to pay the arrear of rent. This is a ground of ejectment. And in our counterclaim, we have specifically taken up that prayer that evicting the plaintiff, all the plaintiff, and delivering the possession because of default in rent, and to realize arrear. This was our counterclaim. Your lordship, my lord will see page 51. Now that paragraph number my lord, how a tenant is to be taken to be an occupancy tenant. There is a way. Procedure 23, 24, 25, section 23, 24, 25, 26 has to be followed to confirm that the particular tenant are occupancy tenant having khotian, final khotian, records of right. I will just
Section 26.
23 to 26. I will just 23 to 26. Acquisition of ownership right and intermediate right by the tenant. Then 24, they have to pay compensation. The application has to be made to the DC. There is a process, my lord. Then there will be an apportionment of the compensation. That means calculation of the compensation. Procedure for the payment of compensation. So this has to be followed to make any tenant to be under the final khotian, to accept that, to be for the lands of records of right. Now, my lord, I'll just, why I'm saying this, I will just bring my lord's attention to in my memo, paragraph 21. How the appellate court erred, my lord, where it had gone wrong. That is, in fact, it has been mentioned at paragraph number 21, page 74 of my appeal memo. It is described. It is pertinent to mention herein, my lord, paragraph 21.
Got it.
Here that in order to acquire the ownership right of the landlord, an occupancy tenant should apply under section 23 of the Tenancy Act. and such application should be made in Form 5 of Rule 9 of the Assam Tenancy Rules 1972. When claim is made, the Deputy Commissioner is required to cause an inquiry under Rule 10 regarding the eligibility of the applicant to acquire the intermediary right and the ownership right. Only when the competent authority is satisfied, then there is a prima facie case for declaration under Section 23. Notices are to be served in Form 6 to all persons mentioned in the application of the occupancy tenant or to any other person who might have legitimate interest on the land. Objections and thereafter to be presented within 1 month of service of notice, and any evidence is adduced by the parties are required to be considered before right to be declared under Section 23. Thereafter, the compensation amount to the patta holder is to be decided under Section 24. Payment of compensation with due notice to the landlord is required to be made under Section 26 of the Tenancy Act. Once the payable amount is quantified, the deposit of the compensation by the occupancy tenant is mandatory, where after declaration of the ownership right can be made under Section 23 of the Tenancy Act 1971. In the instant case, no such evidence is brought before the learned court below for claiming the ownership of the plaintiffs. So first, my lord, it is not proved that they are occupancy tenant. First, we admit they were tenants, but not under such as a final quotidian, as a final land of records.
No, if you were admitting that they are the tenant under you,
we say, my lord, somewhere we admit it is a
then
fact.
admitted
we
fact
say
need
that
not be proved.
Uh-huh.
Admitted fact need not be proved.
Yes, but not quotidian.
Mm.
Quotidian will give too many rights.
Mm.
Final quotidian will give too many rights.
Mm.
But as a tenant, only if I hold them to be a tenant, not under this act, then things are otherwise. Then things are, my lord, simple principle of tenancy would be if they violate or if they fail to pay rent, then at that point of time they will be whole defaulter. For abandoned caution, we accept that they have quotidian, they have right. Still, if they violate rent, they are liable to be evicted. So in this case, by our counterclaim, by our written statement, by the DW1 and DW2, my lord, I can go through that evidence. It is our stand is this, appellant stand is this. Since 2012, they refused to pay the rent, and the proper if they fail to pay the rent, then the proper procedure would be by a civil proceeding in a competent civil court, which we approached. But the learned court below, both the courts below, my lord, has not taken up that view, and for that reason, my lord has made a query: who is liable to pay the rent, and who has to keep, whose onus is to prove that they are paying rent. Section 37 of the said act, it says every tenant who pay his rent shall be entitled to obtain forthwith from his land a written receipt signed by the landlord or his authorized agent. No document, any iota of evidence to show that they were paying 1/5 of the proceeds of the land in kind, that is the crops. In 2012, we admit, till 2012 we are receiving, but after 2012 they are paying. Onus should be on them even by this act. Even the landlord is bound by this section 37, that they are bound to give a receipt, and it is the duty of the tenant to take a receipt. Even if the landlord do not pay the rent on the land received, they are liable for compensation. They have to. So here in both the learned court below, I have gone through the judgment. My lord, I can point out, they say that the DW here also, it says my lord, at paragraph 29, although he participated, DW participated in the said trial.
29 of which judgment? Trial court judgment?
No,
or
my lord,
contempt court?
title appeal. 78, page number 78, my lord.
Paragraph number?
Paragraph number 29. My lord, here, what we find, I find, my lord, that there may be some misunderstanding on part of the honorable court below. Defendant number 1 in his evidence took a stand that due to his old age and ailment, he could not initiate any legal action against the plaintiff in the year 2012 or thereafter. The said explanation is palpable and acceptable as he failed to support his stand by documentary evidence. In fact, that, my lord, what I understand from this paragraph, learned court below has taken up the view that I should have supplied some documents or put into evidence that from 2012 we are not having the rent. This is wrong finding of the law, because it is always the plaintiff who have instituted the suit. They should have shown that till date they have been paying, because my lord will kindly see my lord, may I just to substantiate this, page 11, to just substantiate this, page 11, this point.
Yes.
Paragraph 6. It is the stand in the plaint that the plaintiffs inherited the suit land as occupancy tenant of the defendant number 1. Here, my lord, I am taking that plea that the occupancy tenant is a must secure tenancy, my lord. But in this case, they are not, not so. Of the defendant number 1 and used to pay the respective rents under their occupation. And it states that the father of the defendant number 1 also died and defendant number 1 become owner of the suit property. All are admitted. And automatically the plaintiff regularly paying the rents. That is 1/5 share of crops or its value to the defendant number 1 from the date of death of the father. This part has not been supported by any documentary evidence. Then it could have been, my lord, if they could have shown till date or till institution of the suit, they have been paying rent altogether, then there would have been a case. And and my lord will also see their prayer, there is no prayer as such that to declare them that they are lawfully paying the rent. There is no declaration. There is no prayer for declaration. Only occupancy tenant or a tenant would not suffice. They have to also prove that they have been in regular payment of their rents. No land receipts, rent receipts. Now, my lord, এখানে পঢ়ি দিবা নহয় PW খিনি My lord, 38 again, 38 of the Tenancy Act. Deposit of cash rent or money, deposit of cash rent or money rent. When a landlord refused to accept, suppose, my lord, you have refused, then they should have approached the revenue officer. That is not there. And in pendency of the suit also, at least they should have, and by NJ case or whatever, my lord, it could be, rents could have been also deposited in the court, in the honorable court. That is also not there. In pendency, from 16 to till to 2026, there's nothing on record to show that they have been alternately paying. If we refuse also, suppose they're pleased that we have refused, it says, my lord, accept any rent when tendered to him by a tenant or when the tenant is in a bona fide doubt as to who is entitled to rent, the tenant may make an application to the revenue officer in the prescribed manner seeking permission to deposit the cash rent. It is not their pleading that they are paying till date. Nowhere. Court has held otherwise. Court say, no, you are not able to, you have failed. The defendant have failed to show that they have not been, that he has not been receiving the rent. It is the other way around. My most humble submission, my lord. First, they should have stand up in their limb. We have paid, these are the rent, and after even in case of refusal, we have approached the revenue officer or to the honorable court to deposit the same. That has not been there. My lord, 58 again. Now 58. On the learned court below, both the court have a consensus view that they are the occupancy tenant. But 30, 23, 24, 25, 26 have not been followed. And finally, 58.4. In any suit or other proceeding which a record of rights prepared and published under this chapter or a duly certified copy thereof or extract therefrom is produced, such record of rights shall be presumed to have been finally published unless the contrary is proved. Here there is, in this particular case, they are not even able to prove that they are occupancy tenant. If they would have been able to prove, then burden would have lied on us. We admit they are tenants, they are temporary tenants, but not under this safeguard under this particular act. This is my case, my lord.
Okay.
Now, my lord, my substantial question of law was that whether the land should devolve upon the landlord. In case, now, my lord, first point is that they are not occupancy tenant, so as to be protected under the temporary. That is by the judgment itself. Appellate court has specifically mentioned that there were no evidence to show that they have gone through the whole process, application to the deputy commissioner, compensation, fixation of compensation, paying of compensation. Finally, they have been under 50, they have been given Khotian. They have Khotian, but after that also this process has to go. Finally, for a occupancy tenant. Now, suppose it is for abandoned caution taken that they are tenants. I would say tenants. They were having the burden to prove the tenancy with that they are paying the rent regularly. Now, if they do not do that, my lord, the land should devolve upon the present appellant or the legal heir of the appellant. This should come back because provision is this under 50, 51 and 50.
No, you were submitting that they are tenant under you, but they are not occupancy tenant.
Yes.
But whether the act classify two kinds of tenants, one is occupancy tenant and another is simple tenant.
My lord, tenant, to be a occupancy tenant,
Hmm.
they have to
No, is it
fulfill
defined in the act?
but on record it is very obvious that they are not occupancy tenant. Now, if they are tenant, regular tenant,
It's clear, my lord.
Section 5
nah,
is.
my
So since when they are tenant under you?
they are under long time. But my lord, this will come
Long time.
only when the procedure has been followed. Yes, to be a occupancy tenant, it has to be at least 3 years. But that is not only the criteria, and they have to fulfill the particular to have a khotian. Because both the codes below are pointing out one thing, that since they have khotians, they have the right to use the land. But they can use the land even if they are if they have khotian, but they have to pay the rent. That my senior friend will also not. I don't think my senior friend will dispute that. The rent has to be paid by them. In 2012, this is criteria for occupancy tenant. My lord, these are two different aspects, my lord. This is a criteria for occupancy tenant. But he will qualify to be a occupancy tenant only after following 23. And a record of right has to be, because they are exhibiting khotians. They are claiming their right from khotians. And 50 says, 50 of this act, particular act says, when 23. Acquisitions of ownership right. That is a record of right. Here, both the judgments are again saying that there are khotians. They have khotians, so they have the, it says, there, my lord, 17, paragraph 17 of the appellate court. That one point is again and again, it is being highlighted. It is well settled that a tenancy quotients in respect of the suit land were issued. Paragraph 17. In favor of the predecessors of the plaintiff 1 to 4 under the provision of Assam Tenancy Act 1971. My lord, my main crux of my submission is not that whether they are occupancy tenant or tenant, but for invoking, because both the court below has invoked that under the Assam Tenancy Act 1971, they have the right of records, khotians. That is where I am saying it is not, the process has not been fully followed. so as to help. Now, second limb of my thing is this: suppose we understand that they are tenants under us by way of implied or by deemed way, they are tenant, but not admitting their quotients are in accordance with law. We are not. Now, suppose we admit that they are tenants under us, rent has to be proved by them. When they have averted in their plains that we are paying 1/5 of the crop grown out of the land, then it is their duty to show that they are paying the rents. And
How the trial court has dealt with that issue?
title suit, my lord, title suit, that is interesting, my lord, that title suit on us is burden is given to the defendant. Paragraph 5, paying 1/5. Paragraph number 5, they have said, my the learned trial court said tenants of the defendant, both of them left in the year. The plaintiff number 9, 10 stop giving. I put up counterclaim seeking following reliefs. Page 37, 38.
No, what is the finding?
Finding, my lord, at page 38, these questions were whether the suit is maintained or everything, my lord, counterclaim. And similarly, in page 39 and 40, paragraph 12. On the other hand, specific case of the dependent number is that the father has developed Kasikota tea estate.
So issue number 5.
Yes.
For non-payment of rent as alleged by the defendant number 1.
Yes.
And what is the finding?
Issue number 5. Issue number 1, issue number 4. Issue number 5
They have
regarding the claim of the
decided
defendant,
negatively.
the plaintiff lost the status of tenant for non-payment of rent. As all the three issues are interrelated, isn't this? The predecessor of the plaintiff, by dint of their status of tenant, has been occupying their respective shares and also residing over a share of constructing houses and living thereon with their families till the death. Thereafter, the plaintiffs inherited the suit land. The father of the defendant one also died, and the defendant one became the owner of the suit property, and the plaintiff have been regularly paying the rent. That is 1/5 share of the crop of the value of the defendant value to the defendant one from the death of his father. It is alleged that all of a sudden defendant number 1 tried to evict the plaintiff by showing threat, and for the purpose lodged the false case plaintiff number 1, 2, 3, 4 to 1, 2, 3, 4 and 12, alleging that the plaintiff attempted to occupy the said land illegally. Under these facts and circumstances, the plaintiff have instituted the instant suit for declaration. On the other hand, the specific case of the defendant on 1 is that his father has developed Kasikota tea estate, but due to some unforeseen reasons, the tea estate could not be continued as planned, for which his father allowed some people to cultivate some portion of land. They continued to cultivate in giving the share of crop to his father and then to him. That is defendant number 1. According to defendant number 1, the father of the plaintiff were allowed only to cultivate in the land and not to construct houses over the land. And thereby, though the defendant number 1 has denied the status of the plaintiff as occupancy tenant, he has admitted that the father of the plaintiff were tenant under his father. And the defendant number 1 has also not disputed the claim of the plaintiff that their fathers were occupancy tenant under the fact, under his father. Further, the case of the defendant 1 is that government has acquired 486 bigha, 2 kotha 12 less of land out of the total land of Kasikota tea estate as ceiling surplus land, and the plaintiff occupying his large chunk of ceiling surplus land and have their permanent dwelling house in addition to cultivation of various crops in different regions. Defendant number also contended that from the year 2012 the plaintiffs stop paying 1/5 share of the crop in respect of the land
Oh,
described.
okay, Mr. Hazarika.
Yes.
Here, the trial court
Yes.
has shifted the burden to the appellant here, and that is
Yes,
the
yes.
defendant number one.
Yes.
But in fact, the burden of proof lies upon whom?
Lies upon the plaintiff, my lord.
Plaintiff.
Yes, because they have averted. So whatever they have averted, they have to also
Establish the same.
corroborate by or to lead evidence to that respect. Because their specific thing is that we are paying 1/5 even after death of the father to the defendant number one. So, my lord,
Okay.
even thereafter also, my lord, this is my case. So, my lord, once the area is not paid, 51 of the Tenancy Act, my lord, it says it is the ground for eviction, and the power lies to a competent civil court. I'm just again pointing out that 51C, that he has failed to pay the arrear of the rent. These are the grounds of ejectment.
No, already you have shown those grounds.
Yes, yes, my lord. Yes.
My lord, it shall be clear if you read the judgment of both the courts.
Pardon?
Because there is a concurrent judgment, my lord.
Yes,
If you
that
read
is
the
there.
judgment of both the courts, then matter will be clear, my lord. Because some portion has been missing, my lord, in the submission. May I read the judgment?
No, the question is, we have to confine ourselves to the substantial question of law framed by this court on 31st of May 2023. The substantial question of law is whether occupancy tenant is mandatorily liable to pay rent proceeds out of the land so use belonging to the landlord.
So that is a settled principle, my lord, settled law.
Uh,
As per provision of law, he is liable to pay. Tenant is liable to pay the rent.
Liable to pay the rent.
That is clear. So that's
now the question is whether he paid the same.
Well, that is the factual position. Both the courts held in my favor. Both the courts, lower courts, held all these points in my favor. Whether in the second appeal.
No. They have shifted the burden to the defendant number one.
My lord, in that case.
Burden of proof lies upon whom?
They have asserted that they are not paying.
No.
But
in the plaint, you have asserted that you have paid rent to them.
Now, suppose assuming, my lord, I have not paid the rent. Then in that case, I cannot be evicted under this law.
You?
I cannot be evicted under the provision of this law. Because there is a specific provision to file a rent suit. Only after filing rent suit, the rent can be realized. There is no provision for eviction. Even if I fail to pay the rent.
No. There is a provision for ejectment here.
Yes. That is on different ground.
Yes.
But that provision is also not applicable in the present case. Because I have been declared the occupancy tenant by both the courts. That is the factual question. "51 grounds of ejectment." That is first paragraph. An occupancy tenant shall not be ejected by his landlord from his holding except in execution of a decree for ejectment passed on the ground that he has used the land comprised in his holding in a manner which renders it unfit for the purpose of tenancy. Only in that case, after passing a decree against him, there can be ejectment. The second point, paragraph, any tenant not become occupancy tenant, that is not applicable, which has been shown by my learned friend. Any tenant not being an occupancy tenant, but in my case, we are occupancy tenant. It has been declared by both the courts. Those provisions are not applicable in my case. First is applicable. If I have,
No, he has a file counterclaim
yes,
for ejectment,
no, that is applicable.
but courts below have dismissed the counterclaim.
No, applicable in only in case of non-occupancy tenant.
Hmm.
In case of occupancy tenant, the first provision is applicable. First paragraph, not the second one. The ground is there, non-payment of rent, area rent. That is applicable in case of second one. Even if I fail to pay rent. May I read again, madam? Any tenant not being an occupancy tenant shall not be ejected from the land of his tenancy except in execution of a decree for ejectment passed on any one or more of the following grounds. So there is one ground that is area of rent. So that ground is sufficient. But that is applicable in case of not being an occupancy tenant. We have been declared as occupancy tenant by both the courts after going through the records. And even in case of rent, there is a provision for filing a rent suit.
Under which section?
Section 27, liability to pay rent. Section 27.
Yes.
Notwithstanding anything contained in any law, custom or agreement, no tenant shall be liable to pay rent, whether in case or kind, in a rate exceeding the maximum rate of rent as provided for hereinafter following. So section 28 says the maximum rate of rent. And next section 35 regarding area of rent. Rent not paid when it falls due shall be deemed to be an area. Next section important 36. Rent suit. No area of rent shall be. Has your last gotten? No area of rent shall be realizable otherwise than by rent suit filed in the competent civil court. The procedure for such rent suit shall be according to the provisions of so and so. So that first line is important. Rent shall not be realizable otherwise than by rent suit. He has not filed a rent suit. Whether I have paid it or not, that is to be decided by the court. Now, on my plate, they have filed a contract claim that they have not paid that rent, so it is to be deposited in the court. That cannot be done as part of the complete check. They may approach this court by filing a rent. They have specifically admitted that the present respondents are the tenants and that the father of the father.
Yes, Mr. Hazarika.
My lord.
Under which provision the tenant is liable to be evicted for non-payment of rent?
My lord, here, first, my lord, page number 23,
My lord, learned friend, senior learned friend has pointed out, these 2 points I'm clearing, my lord, clearing. Number one is that we have not filed a rent suit. But page 23 and 24, our very prayer in the counterclaim is for realization, specific realization, 57,000 from 1 to 3, then 4, 5 to 2,61,000, and 9,16,000, 9,600 from 6. So all these we have. It is not that we have not asked for realization of the area. It is our specific prayer. And now, my lord,
No,
that
you have
that-
submitted that
Rent-
for
rent.
non-payment of rent, they are
Yes.
liable to be
that
evicted.
that substantial question I have framed, my lord, at C. Whether default in payment of rent proceeds by the occupancy tenant to the landlord liable the occupancy tenant to evict from the land in use. This is the substantial question, my lord. So here, my lord, that 51 my lord, 51.
Yes.
If my learned friend goes on only up to that,
Subsection 1, yes.
yes,
That
subsection
is in
1.
respect of occupancy tenant.
Section 1, my lord. I'll go to the 2 also. 1, my lord, it says
No, 2 is
without.
applicable only in respect of tenant, not being an occupancy tenant.
Yes. So here,
So that subsection 2 will not be applicable in your case.
my lord, that is why I, from the very beginning, I've said, my lord, to be an occupancy tenant, one criteria is 3 years. That is acceptable. But the 23, 24, 25, 26, it has to be followed. And if not followed, then it will, I humbly submit, it will come under the tenant only. And here also, one ground, my lord.
Is that the requirement of law?
Yes, that is why I framed that law, my lord.
Occupancy, definition of occupancy tenant.
Yes. Occupancy.
Section 5.
5.
A person who for a period of not less than 3 years has continuously held land as a tenant shall have a right of occupancy in that land.
That is what, my lord, my humble submission. True. Over 3 years, occupancy tenant. But that is not the sole ground to issue Khotian. For Khotian 23, 24, 25. That is record of land. My lord, and here, that is why I'm saying
There is a finding of learned courts below that the plaintiffs have the Khatian.
Plaintiffs have the Khatian, my lord. But at the same time, that is why I said paragraph number 74, my lord, page number 74. Again, I'm reading, my lord. This paragraph very important, my lord. That is why. So only for this paragraph, my lord, it will come under any tenant.
No. That compliance of section 22,
Yes,
23 are required only to acquire the ownership right, not for occupancy right. You see the wording, acquisition of ownership right.
Yes.
And intermediary right.
Yes.
By the government tenant, government for tenants.
Yes. Now, my lord, now for that in the plaint, what was the prayer, my lord? Declare that the plaintiff are entitled to a decree of right, title, and interest over the said land. So their stand is that, my lord, they are having ownership over the land. That is why they have been asking for decree of right title interest.
No, you have submitted that
Yes.
mere occupancy of the land for more than 3 years,
Yes.
the plaintiffs would not entitled to get the right of occupancy tenant. For that purpose, they have to comply with the
23,
section
24
22 and 23.
to get the
But these
ownership.
two sections are not related to acquiring occupancy right. These are in relation to acquisition of ownership right and intermediary rights. Acquisition of occupancy right is covered by section 5.
Section 5, my lord, it is a definition. It says that, my lord, it is the difference between occupancy and non-occupancy. But, my lord, any tenant, my lord, that's
Mr. Hazarika,
yes,
you seems to be not clear on this point.
yes,
You come prepared, we will adjourn the matter.
yes,
We keep it as part third.
yes, my lord.
We will list it on next Tuesday. Okay.
My lord.
10th of March. No. Getting. Maybe this is only on one point. No, all right.
There is a
17th.
10.
March.
My lord, may I pray, part third, maybe, my lord, if possible, to be taken up in the top of the list, my lord.
Okay. Any inconvenience? No. Heard, Mr. T.H. Hazarika, Learned Counsel for the appellant, and Dr. P.K. Goswami, Learned Counsel for the respondent. Heard in part, list the matter on 10th of March as top of the list item.
I'm deeply obliged, my lord. Deeply obliged.
You got to submit only on this
Yes,
point.
yes, yes, my lord.
Not on other point.
Yes, yes.